Pledge allegiance to the flag of the United States of America, and to the republic which stands one nation under God,
Recording in progress.
and justice for all.
Father, again, we just want to thank you for the privilege of representing our community today. And so we pray for added wisdom and insight just in our discussion and any decisions that need to be accomplished. So we do give you thanks for it in Jesus' name.
Introduction of visitors. So we have Katie Arnold, Kristen Masteller, Derek Allen, Matthew Wade, Amanda, Kevin Shuddy, Morgan Demeraux, and a Galaxy. So, does anybody have any comments prior to community comments, or should we have community comments? Do we have any community comments? Anybody have any comments for us? Okay. Commissioners?
I've got some community comments, continue to answer questions that were sent to us.
Kristen asked if there's anyone in the waiting room. No. Not at this time that we're seeing.
You can read that.
Only with bifocals.
Okay. We had 3 questions that I hadn't answered previously on the pages that were.
I'll to follow up with him later, you guys. We can just power through some of this stuff really quick. The main thing I wanted to just go over with
Okay, we lost you, Kevin. If that was you, we lost you. We can't hear you. Morgan, can you still hear us?
Yep. Yes, I can hear you just fine.
Okay. So Kevin, if that was you speaking, your audio is turned off for some reason. We can't hear you.
Nope, all good on my end. Sorry, guys.
Okay. Okay. So who had the comments for us to start with? Okay, John, go ahead.
Okay, there were 3 questions that have brought up that I hadn't covered before. And one of them had to do with personal use of command vehicle by the chief. And every fire chief in the district is on call 24/7 and has access to a command vehicle.
In the county, you mean?
In the county. And we don't consider it a problem when in town for department business to carry out other errands while they're there because of the distance involved. And many times you'll see department vehicles in Walmart or Fred Meyer just because they're consolidating errands. Another one had to do with added insurance for added riders. And this was back in 2018, where after a commissioner conference, we found out that we didn't have insurance to cover anyone who rode in any department vehicle, either a patient or a family member who was going to go along with them on the call. So we found out that we didn't have that insurance, and it was important that we get it on it. So that's why it went. Another one had to do with the prices of filling pools. And so we did some research on that, and probably within the last 3 years, we've only filled 5 swimming pools from the department. We've asked for volunteers to do that. And we don't consider getting money for that because we look at it as a public relations for the support of the fire department. And so it's a thank you for all the support that people are giving to us. So those should take care of it.
But one note to that, also on the swimming pools, I know when I've filled them for people, we also tell you that if we fill your swimming pool, then we have a fire and we need that water, we're going to suck that water back out of your pool with our tenders. And everybody's been receptive to that, within our area. So
Okay. Another question that had been brought up last week that was sent in regarding the training for open public meetings. And the chief and the secretary have both completed updated training with the AG's office. Another one is, have we been responding to public requests? And we have. We've had numerous ones, and they're currently working to fulfill the requests that we have. So some of the people that sent them in know that you have been responded to, and so we're still working on the others. What was the date of the first employee paid employee? And that would have been, is that 2005?
January of 2005 was our first pay.
Okay. Mike was paid before that, wasn't he?
No, that would have been the first full-time paid employee would have been Shirley,
Sure, okay,
our secretary.
okay. Currently, we have 2 full-time employees, and the duties are reflected in the contracts. And let's see, how many calls have Fire District 12 responded to monthly? In January, we had 27 calls. In February, we had 17. So summertime is mostly busy for that time, of course. So hopefully that will answer some of the questions that have come in recently. So I'm done for that.
So Amanda has a comment. She hasn't had any updates on her request. I'm not sure what it is that you're still waiting for, Amanda. If you could let us know exactly what that is, because I thought we fulfilled that.
We got some requests for the policies, and those are available on the website. So anyway, okay.
You can't click on the policies on the website.
You'll have, so we've just checked that prior to the meeting, and we've all been.
Now you can. I checked it like an hour ago and you couldn't.
We had to change the format on that because it was making you download them prior to that. So yeah, we did update that prior to the meeting so that it's easier to read. Okay. You have any comments, Brian?
No.
Okay. Consent agenda.
Question I had was on
Oh, I'm sorry, John, go ahead.
on the chief's report on the February minutes, where it said that there were 2 calls in January, 17 fire, 20 EMS. Did we miss something?
It's
Okay,
a typo.
okay, typo. That would be 37 total for January,
Wait, 27.
We had 27.
27. Okay.
Yeah, it should have been 20 and 17 or 20 and 7 or 20.
That's the only thing I caught, so. Other than that. And the vouchers.
Sorry, should I resend those requests to you, Buck, or do you want me to put them in the chat?
Send it by email.
Yeah, if you want to send them on that website, I'd appreciate that. Thank you.
Thank you.
You're welcome.
Did you get the other voucher with the salaries on it? All right. Well, Brian, did you get a chance to look at that?
Here's the. Any questions? That's expensive at the store.
Mhm. I heard that they're in trouble because they're looking for employees. They had shut down on Sunday.
Oh, I'll make a motion to accept the consent agenda.
I'll second.
All in favor?
Aye.
Aye. Motion passed. Okay, so then we're yours that you just did. Pardon?
Next.
Yep. Old business, audit. Do we have any updates on the audit?
We reached out to them because we have not heard anything from them, and they responded back with, they will be getting hold of us approximately the first week of April to set up our meeting.
They said they still had more questions though, right? So. Maybe there's still something that they were in the email. So my impression from that was that they weren't still finished.
So we are still waiting on the state auditor.
They're still waiting, yeah. They still have, that's
Okay.
not that far enough. Well, we're far on here. During the wrap up, we'll be reaching out soon to set up in person for the end to go over questions.
That's an end interview.
That's the end interview, right?
Right. That's the one that Tina had told us about.
Okay, so that's the latest we've heard, so.
Okay. Roof.
So we have two bids. The third had to reschedule last week due to something. So the first bid we have is from Cooper Construction for $29,837.50. So that's to tear off the existing metal roof, dispose of it, repairing necessary fixes in the skip sheeting on the roof, apply a new vapor barrier, apply new snap block tin roofing, the cleanup and everything would be $29,837.50.
And that's who did the,
That's who
Lake
did our
Station?
Lake Station.
all right.
And then the other one was from A1 Roofing. Their quote was $49,825.63.
How much was that?
$49,825.63. And then the third one I won't have until tomorrow. When I spoke with them on the phone, their ballpark is gonna be around 55,000.
Fuel surcharge.
We'll have to wait for the third quote.
Or do we make a motion to go with the,
Well, let's wait till the third one's in. Hopefully the weather will be better.
Make the weather days.
So, procedure, 3 bids that we have to do, right?
yep. All right, uniforms.
Uniforms, I don't have any updates on them.
Okay. Well, speaking with,
Are there different uniform companies that we have available to us?
But it costs for we have to get patches and everything added, name tags, all that, so it's not just like a generic uniform.
the problem with it is, with trying to have volunteers wear a uniform, is the delay. So
Extra time to get
the extra time. The only volunteers that I know that wear, I mean, our volunteers wear a sweatshirt at least with it, or a t-shirt
to identify.
to identify. A uniform is typically worn by a department that has shifts. Matt wants to know if there's something wrong with the camera. We're not sure why it won't project us.
The same computer.
Everything is the exact same as last time. So
They can't see us?
There's student audio.
Oh,
they're only
If I turn
getting
it around.
audio, so Matt's not getting,
Can we try turning around?
no, let's do it. So there's something in in the program, right?
Because I could, Morgan, when he had his camera on, we could see him.
Right. But it,
All right,
Zoom
thank
is
you,
still-
Matt. Yeah,
Zoom
we're
is
not
still
sure what
recording,
is, but you can, he can still hear us fine, he just couldn't see us. All right. So the contract, we have to take action on that contract.
So at the last meeting, you guys had changed the contract to resemble $1,500 a month and take off the day shift EMT position.
Mhm.
So the contract reflects that. We just took off take off the EMT day shift, and we changed the amount from $2,500 to $1,500. Per our attorney.
Okay. Well, I move to accept the secretary's contract as amended.
I will second. All in favor?
Aye.
Okay.
So new business would be Morgan he's the Assistant Attorney General, who's going to do a short presentation for us. Welcome, Morgan.
Yeah, good afternoon, all, and thank you for inviting me to spend some time with you this afternoon. Let me see if Kelly, Chief, are you able to turn on the screen sharing so I can share the presentation, or do you want to do it from your end?
I will try that right now.
Yeah.
Okay, you are the host now, so you should be able to screen share.
Okay, let me turn that one on. Great, you all should be able to see the opening slide anyways, because let me know if you can't see it, and we'll obviously have to troubleshoot, because today seems to be one of those days that technology is fighting us. I was commenting as we started that my phone audio this morning was terrible. It sounded like I was in a tin can all morning. So I think I got that resolved, but apparently you've inherited the bug that I was dealing with. It says, I just got a pop-up that says there are 2 people in the waiting room. Can you admit those? I'm not sure if I have to do anything with that. But
You are the host now. We don't have that capability. It's on your side now.
Okay, let me find. I will. Oh, it was there. I just lost it. Oh, come on, stop. Find the waiting room. This is the fun part of being all of a sudden being the host, is I get to do all kinds of things I'm not used to with a Zoom meeting. So bear with me. There we go.
If you need to return it back, we can admit the 2.
I think I just admitted them. So Como has entered the waiting room. So I'll admit, there we go. I think I've accomplished it. I've let the people in out of the waiting room. So I'll start again. Thank you very much for inviting me to spend some time with you. We were out at the Mason Fire District 12 end of February, spent 3 or 4 hours talking with the chief and the secretary about public records, helping kind of build the foundation in terms of public records. And in terms of that conversation, it was suggested that maybe we come back and talk with the chiefs and the commissioners to kind of give a little bit of an introduction to you to the Public Records Act. We're not going to go through everything that we talked about when we were out there talking with the chief and the secretary. Really going to kind of focus this on an introduction for you and kind of give you the tools and the information you need as commissioners as you're dealing with public records and getting your bearings. In terms of who we are and why we ended up talking with you. Back in 2018, the legislature said to the Attorney General's office, stand up a local government consultation program working with local governments throughout the state on public records. At that time, I'd been working for the AG's office for about 15 years, doing labor and employment law. A lot of that litigation had ended up in public records. And so when the opportunity to stand up this program came up, I jumped at it. So basically the last 4 years, what I've been doing is working with public records, working with local governments all over the state. Example, like I leave tomorrow for the Tri-Cities. We'll be over there for a couple of days. That's one of the benefits to COVID kind of waning is we've been doing a lot of Zoom meetings and Zoom consultations for the last 2 years, but getting to come out and talk with the chief and the secretary a couple of weeks ago now was really kind of refreshing. So in terms of who I am, in terms of introductions, I'm Morgan Damerow. Like I said, I've been in office for going on 20 years now. I'm been practicing law for about 25 years, which I'm not quite sure how that happened. It kind of sneaks up on you. Last 4 of it has been doing this program. And then about a year ago, I welcomed a new member of the team, Lucy Collis. She came to us from the Department of Commerce, where she was the public records officer and the records retention officer. And so the two of us are the consultants for the office. And basically, we provide technical assistance, trainings. The idea is that we help with risk mitigation, identifying best practices, and the whole goal of this program is to help agencies get it correct. Because there's an issue with a lot of jurisdictions that are small or medium sized. There's a turnover of staff, and so they lose that kind of knowledge. And so one of the things we help do is bridge that gap. And so we spend a lot of time talking with new public records officers and new secretaries, things like that, as they're getting their bearings, helping them understand what the Public Records Act expects, what they need to be doing, and then just answering lots of questions along the way. And I know Kelly and the secretary have our information, and they're free to reach out to us anytime. Same with you as commissioners. If you have a question about the Public Records Act, feel free to give me a call, give Lucy a call, send us an email. We don't replace your legal counsel, but what we do is we try to provide current information on what's going on. So what we're going to go today is we're going to talk a little bit about the significance of open government and transparency, just kind of to dip our toes in the water. And then we're going to spend the majority of the conversation about the next half hour really talking about the Public Records Act. I don't really intend to talk about the Open Public Meetings Act. That's a whole separate area of law. I'm happy to talk about it with you. But the focus of the day is really going to be to talk about the Public Records Act. And just in terms of, I'd probably not do my job as an attorney if I didn't give you some kind of disclaimer. The goal here today is to give you some information. It's for educational purposes. The Public Records Act was passed in 1971, and it's changed since then. 1972. And every year, the legislature, when they're in session, they make changes to the PRA. Court decisions inform ourselves about what we need to do with the Public Records Act, what our obligations are. And so my goal today is to give you the current lay of the land, where we stand right now. And then as time goes on, that's why training and why the PRA expects training every 4 years. I really encourage folks to do it more often, just so they're current with what the expectations are, because every once in a while we get a court decision that gives us something that's new and something else we have to do. Just amid somebody else. So why do training? I mean, because the idea of training is it's really your path through the forest. It's your ability to get from where you are to where you intend to be, where you want to be. And there's lots of really good reasons to do it. One is because it's obviously it's good to know what the expectations are so that you get it right, so that you're doing your best. And another good reason is because every once in a while something will go wrong. Sometimes it's inadvertent, it's a mistake. My experience working with local governments is that everybody's trying to do their best. They're making their best decisions based on the best information they have. But sometimes an exemption will get missed, or something won't get responded to because something will get miscalendared or things like that. It'll end up in a public records lawsuit. So one of the things the courts look at is, and one of the purposes behind the penalties in the PRA is to encourage agencies to get it right. And so one of the factors of that is, does your agency take it seriously? What kind of training do you have? Which is why I think it was really great that we got to spend all that time talking with the chief and the secretary about Public Records Act. Why I really appreciate the fact they invited us back today to give you some information about the Public Records Act. Because if you can show the court that whatever happened, whatever went wrong, was not a systemic problem, was an oops kind of moment, it really helps the judge understand where things are. If you look at starting in the lower right hand corner here, the high watermark for penalties in the PRA now is a $2.6 million judgment about 6 months ago now against the city of Tacoma. That's on appeal, but that's still a really big number. Versus if you look at the other cases that go well for agencies, they recognize they did something wrong. The lowest penalty we've seen is $14. Where that training comes into play is that if you can show the judge that this was not a systemic problem, that this was something that happened that shouldn't have, but we've corrected the problem, that helps the court recognize that the penalties for encouraging future performance, future satisfying your PRA obligations doesn't require a $2.6 million judgment. It can be a $14 judgment is the lowest we've seen, but it can be the case I was just talking about. That Kittitas County case was about a $15,000 penalty, and then another about $45,000 in attorney's fees. So there's the economic reasons of why to do this. But there's a whole other reason why you should really pay attention to the transparency laws, the OPMA, the PRA. And part of it is this idea that Supreme Court Justice Brandeis talks about in terms of sunlight is the best disinfectant. People really have questions about what we do as government employees. And in the absence of good information, sometimes they will fill in those blanks with their best guess, or they'll think that there's something nefarious going on. And that's really what the Public Records Act is really designed to account for. People get to see the stuff we're relying on in making our decisions. And they may not agree with the decisions that are made, but they get to see the underlying facts. And then it's not a question about, they're hiding something. It's a question of, we don't agree with the decision, which is a very different kind of conversation. And then the other reason you should care about transparency laws, and these are just some headlines I pulled out of random newspapers around the state, but think about your community. And if their exposure to you is these kinds of headlines, what's the impression that's going to build for the members of your community? It's not, I think, where agencies want to be. And I think by and large, agencies really do try to do their best with the Public Records Act. When we start talking about some of these big judgments, it's because there were just some really unfortunate decisions made and things like that. But we'll kind of talk about those as we go along here this afternoon. So kind of diving into the Public Records Act. And like I said, we're really going to talk about this from a high level point of view so that you as commissioners have a good bearing on what's expected of the agency under the Public Records Act. So you can help inform your decisions. When the chief says, yeah, we need to make some changes, or if the chief contacts you for a reason looking for some kind of records, you kind of understand what you need to do and you realize the expectations upon you. So big picture wise, and these are just the high level issues. Your agency has to appoint a public records officer, and my understanding is you've done that. You've got the chief sitting in that role. The PRA specifically says that you need to adopt the public records policy. And this isn't a hard thing to accomplish. And the idea behind it is it's your playbook. It tells the requesters, tells the community what they can expect of you. It tells them what you're going to be doing, what they need to do to make public records requests. It's really a chance for you to educate yourselves, figure out what you're going to do in responding to public records. What's your process going to look like? And at the same time, be a tool for your community to know that, oh, if I want to make a public records request, the best way to do that is to send an email to this email address at the fire station, or things like that, or to come in and talk to the chief and drop it off in person. You need to, as part of that, adopt fee schedules. In the PRA, there's a couple different provisions that let agencies charge for the actual production of records. That's not the time that your staff is going to spend looking for records and copying records, and getting them ready for redaction and things like that. It's that final step of the process where you're actually going to be producing records to the requester. Something to keep in mind is that there can be no charge if they want to come in and inspect records, and the PRA says that you need to let that happen up to 30 hours a week. The good thing about that is that most requesters don't want to spend that much time with you, so to speak, and they'll work with you to schedule a time to come in at a convenient time. Every once in a while, we see an agency, and this happened with a small town in Eastern Washington, where they tried to say, we're too busy for this. And while the court was sympathetic to the impact the Public Records Act was having on the agency's operation, court looked to the specific way that the legislature has drafted the PRA and said, it says 30 hours a week. You don't have the ability to restrict that. And keep in mind, I'm talking about all this in normal times. Right now, obviously, we're still working through the COVID-19 pandemic. We're still under the Proclamation 2028-15, which has suspended some of the in-person components of the PRA, including that 30 hours a week. But in general times, that's what you need to do. You need to identify what your most common exemptions are. And the idea behind that is it lets the public see, generally it gives them an idea of what they're not going to see, what records are not going to be turned over. In like an employment context, it's things like you're not going to get copies of dates of birth if you're, there's going to be a limited release for that. You're not going to get social security numbers, passwords, for fire districts that have medical records. That kind of thing. You'd cite the HIPAA or the 7002. That's our Washington equivalent of that. And these are all, we've shared some of these with the chief a couple weeks ago when we were out there. And I know that this is in the process. Also, poster, what are your customary business hours? When's the agency open? When can people drop off Public Records Act requests? And then you need to maintain a log of all your Public Records Act requests that you get. Things like who the requester is, if they tell you, because they can be anonymous. What did they request? What was produced? When was the request closed? What wasn't produced and why? And we gave a copy of this to the chief when we were out there. But this is kind of the foundation, and this sets the stage for, basically how public records are going to be processed by the fire district. I know we shared some sample policies, and there's also model rules that the AG publishes in the WACs that are a great tool as you're looking at that development of your PRA process, your PRA rules. So from a bigger perspective, so what are we talking about when we're talking about public records? So I just noticed a pop-up about muting Mason 12. I'm not sure that I see the control window for that. If I will poke around a little bit. It seems to have gone away, so I think we'll call it good. So what is a public record? And we could go through the statutory definition line by line, but doing presentations that way is kind of a little bit boring sometimes. So we came up with kind of a graphic way to help you understand what's going on. Then there's kind of three components to this. One is it has to be a writing. And if you look back to 1972 when the PRA was passed, we were talking about paper. That's what we had back then. The computing power we have now would have taken a very large building to do versus what we walk around now in laptops and things like that. But what's happened is we've moved from 1972 to where we are now. The way the PRA is written, it says writing, but the definition of that basically is any form of communication. So as we've moved into emails, the courts have had no problem saying that's a writing, that's a communication. Voicemail, while not technically written on paper, it's an electronic means of communication, so that's a writing responsive to the Public Records Act. Most recently, what we've seen in the expansion of technology and the PRA keeping up with that is looking at social media and looking at things like Facebook and text messages. And so all of those various ways we communicate come within that sphere of being a writing. Another piece it has to be related to the conduct of government or a proprietary function. We don't see a lot of challenges to that either. It's kind of, the question is this something that your agency does? For the fire district, it is your scheduling, it's your responding to calls, it is the contracts for replacing the roof, that kind of thing. All those records relating to the operations of your business, that's related to the conduct of government. Where we've seen a little bit of challenge recently has been if there's been personal emails kind of interwoven into agency devices and agency accounts, then the courts have said, you have to look at each specific writing, each specific email in that case to say, is this related to the conduct of government, or is it my grandma's cookie recipe that I happen to be emailing to somebody? It's that kind of a thing. And then the third piece of it is it has to be something prepared, owned, used, or retained. And a good way to think about that is the acronym POR, obviously the first letter from each of the words. So all of the emails that you send, if you're drafting a memo, if you are entering into a contract, if you're signing a contract, and it sounds like you were the folks that were writing a contract, an employment agreement for your secretary. That's something the agency has prepared. That fits within that definition. If it's something you own, let's say the fire district was going to acquire a new piece of property and hire an engineer to do a feasibility study. Could we drop a well here sufficient to supply enough water that we need? And you bought that report from an engineering company. That's something you own. That's a public record. Let's say that it's part of that process of building a new fire station. You then went on to the internet and you looked at plans for various fire stations, and you found something that was informative to you, and it became part of your decision-making process. You used that as part of your decision in terms of what did you want that new facility to look at. So the question, you've used that in terms of your decision-making process. It's not everything you search for on the internet. It's not everything that pops up on a Google search, because, you know, we all know if you've done a Google search, you get about 1,000 things that aren't relevant and 2 things that are, but it's something that you use that informs your decision-making process. And then it's things that you retain. Let's say a good example of that is emails that you have. If you haven't deleted an email for 20 years and the retention schedule on that was 6 years, you've retained it. It's still responsive. It's still a public record. You still need to provide that if it's responsive to a public records request. Where we've seen this, like I said, being pushed recently is in this idea of private devices. So if you're using your personal email accounts, or if you're sending text messages from your personal phone number, if you're talking about the fire district on your social media accounts, if it's within the scope of your employment, and for fire commissioners, it would be if it's part of your job as a fire commissioner, it's likely a public record. And the test for that is if your job requires it, if your employer directs it, or if it furthers your employer's interests. So if it satisfies any one of those 3 items, it's likely going to be a public record. And there isn't a bright line test for this is or this is not. But what we talk about is, and the courts do this record by record by record. If you looked at the litigation of this over the last 10 years, 5 years or so, what you'd see is the court looks at each specific communication and says, is this within the scope of employment? Yes or no? And if it's yes, the answer is that's a public record. And if it wasn't produced as part of a PRA request, that would be a violation of the PRA. We'll talk a little bit about searching for public records and about your obligations with that, which is why you really need to front load this and keep track of where are you communicating. One of the best practices that we identify is don't use your personal accounts. You know, when I travel for my job, I carry 2 phones. I have you know, and they're both iPhones. They look a lot alike, but I will not use my personal phone for work because I don't want to cross the streams, to use that a Ghostbusters reference. And so, you know, really one of the best practices is let work stay at work. Let the fire district manage your records, because once you start doing that, once you let the public records invade your personal accounts, you are taking on all kinds of obligations. Because the bottom line in all this is all these records are not yours. While you draft them and you put a lot of work into them and things like that, all those records, all the communications about things that the fire district is dealing with belong to the agency. And you know, one of the things that I'm kind of a public records nerd, and so I actually have things about public records that scare me. And one of the things that scares me about public records is former employees and about former elected officials and what happens when they leave, because they may still have public records that belong to the agency. And how do you get those back? What if you know, what if you're a former chief and you decide to leave and you've been using your personal device and your personal accounts, and then you move to Arizona and nobody knows where to find you? I've got huge question marks in my brain about what to do in those kinds of questions, in those kinds of moments. So that's kind of a foundation to, you know, what is a public record. So let's move as one step forward to, you know, so what kicks off your obligation to produce records? And the key, the starting point is always a public records request. And so what does that look like? And there is no one set form for this. The requesters can't be required to use our form, so to speak. If we have a template, they can't be required to use it. That doesn't mean you shouldn't make a template. You shouldn't have something on your website. One of the best practices is to have part of your website dedicated, and it doesn't have to be the top page. As much as I'd like to think what I do is the most important thing in the world, you know, I'm try to be realistic, and it's not. But you should have something on someplace on your website that has public records, and on there should be either a portal that lets people automatically submit a request to the agency, or a form they can fill out, or both, a copy of your public records policy. Because, you know, if you put these tools out there, most people will use them. There are very few people out there that are trying to use the Public Records Act for profit. Most people are really engaged in their community and really want to know what's going on. And like I said, the Public Records Act is a really powerful tool that they have. So what does that request look like? And sometimes requesters will say, this is a PRA request. Sometimes they will cite 4256. Lots of times they'll cite FOIA, which is the Freedom of Information Act, kind of the federal equivalent. A very different function to it, by the way. It may just be a letter that is addressed to the public records officer that says, I would like a copy of this, please. So you kind of have to look at it. And like I said, there is no one one form for it. So it's just kind of why the graphics are on here in terms of if it looks like a duck, if it quacks like a duck, then it's a public records request. That being said, there are lots of reasons we turn over records that aren't public records requests. Things like employees wanting to review their personnel file. Things like subpoenas we get from attorneys in discovery, things like that. So there could be lots of reasons why information goes out the door. The PRA is just one of them, but you want to look at, make sure you're paying attention to it, because as I've kind of talked about a little bit already, the PRA has some potentially pretty big teeth if you get it wrong. So the obligation on requesters is to ask for identifiable records. We have to be able to understand what they're looking for. And the other thing about public records requests is they have to actually ask for records, a request for information. So a lot of times I'll see requests or letters sent to agencies that will be something like, tell me why the commission made this decision. That's an information request. You can choose to engage with the person. A lot of people will, as part of knowing that you serve your community. But that's not a PRA issue. And one of the things that we talk about is if you get one like that, to say, this isn't a PRA request, but because, in the interest of serving the community, here, let's provide you some information. Because, we'll talk about what your specific obligations are for the PRA request. So what this means for you as commissioners is that, if you're, and it's particularly happens in a small community, and much like my Mason Fire 12, where people have your email address, you have neighbors, they know how to get in touch with you, and sometimes it's tough to keep them out of your personal devices. When that happens, best thing to do is the second you see it, forward it on to your chief, and so that it can get into the system, so that it can be dealt with properly. Let's say it's your neighbor across the street who comes up and asks you, hey, how do I do this? Your best practice is don't engage with them and say, oh, tell me what you want. Obviously, you want to do customer service, but take yourself out of the loop and send them directly to your chief so that it gets into the system quickly and easily. Because if it comes to you, there's going to be a delay. You're going to get it, and then it's at least going to be some time before it gets to the chief. Take yourself out as the middleman. That's why you have a chief, and there's lots of things that have to happen in a PRA request, and it's really important that those be understood and be tracked, which is another good reason why you want, but I'll get to the second a little bit more, why you want those all to come back to your public records officers so they can deal with it properly. So, because when you look at what a public records request is and how it happens, we've talked about the first one already in terms of what a request is, what it looks like. That's what starts the process. And that's a crucial moment because within 5 days, 5 business days, that is, your agency has to do one of 5 things. If your agency can respond to the request and give them the records they want very quickly, very easily, obviously, that's a great thing to do. You should do that. That's one option. A second option is to deny the request. That example I used about somebody who's making an information request, that would be a time to deny the request. So, you're not making a proper request, but here's some information. Or what if they have the wrong agency? They actually meant to send the request to Fire District 6, instead they got 12, or meant to get to Fire District 4 and they got 12. You still want to respond within 5 days, acknowledge the request, and deny the request, saying we think you have the wrong agency. Best practice, fullest assistance is, we noticed that we think this may actually be something that the Fire District 4 dealt with, and send them to Fire District 4. Or if it's an accident report, they want to send them to the Mason County Sheriff or the Washington State Patrol. That's that fullest customer service piece of it. But the important piece is to close out the request and say, wrong agency, we're very sorry. Another option, and I heard at the beginning of the meeting something along this way, is you can send them a hyperlink to information that's on your website. And there was a conversation about the agency's policies are now posted on the website. That's a great practice. And I always encourage agencies to put as much on their websites as they can. I know that's a challenge for a lot of smaller agencies that don't have the infrastructure and that may be relying on volunteers to make this all happen. But the more you can put out there, the better off you'll be, because that way people looking for an answer at 9 o'clock at night can go to the website and find it. And what you find is the more you put on there, the more you'll find that people won't be submitting their public records request, because it'll be a self-help kind of moment. Another option is that you can ask for clarification. Let's say you get a public records request that you look at it, you're not quite sure what they want. One of the available options is to send a letter back to the requester, and all of this should be done in writing, is to ask the requester for more information, because like they still have that obligation to ask for identifiable records. And if they don't do that, we can ask them to say, can you give us some more information about what you're looking for? Something to watch out for with that one. Let's say they request 5 items and 3 of them are clear and 2 of them are not. You start processing the 3 that are clear, ask for clarification on the 2 that you don't understand. What the requester has to do is they have to provide clarification. And if they don't, you don't have to then try to be a mind reader and figure out what they want for those 2. You can treat those as being closed or abandoned as a common term for it. Still have to process the other ones. We talked with the chief a little bit about that, but just when we were out there, I'm going to give them some tools to kind of work through that process. But that's something else that your public records officer can do. What happens most commonly is that the 5-day letter acknowledges the request and says, dear requester, thank you very much. We received your request. We understand you're asking for the following documents. We anticipate having either the records or a first installment to you by this date. And it has to be a reasonable date. There is no set number for this. It has to be kind of based upon what's going on with your agency at the time. Great example, if you got the same request one time in February and the second time in August, in February, where the department isn't that busy dealing with issues, then a reasonable period of time might be 30 days, might be 20 days. In August, when you're in the height of wildfire season, and there's obviously a significant reason why, if there is a report of fire, you want to act quickly, reasonable might be 30 days, it might be 40 days. It kind of depends on what your agency is doing, how busy your public records officer is. But it still has to be a reasonable period of time, and you have to give them at least a date when they're going to get that first installment. So what happens next? You've got this request, and these are kind of happening at the same time. Then you have to search for records. And we're going to talk really about searching for records a lot in the next slide. But this is where you have to kind of scour your agency for all the public records. That might be in your email servers. It could be in the filing cabinets. It could be in paper files. It could be in personal devices. For you, for the commissioners, if you've been using your personal email or your personal devices, social media, those kinds of places. But we'll talk about search in a second more. So assuming we found everything, your public records officer has compiled it all, has this massive file someplace in your network. Then they've got to go through it all. And this is, I think, where people don't kind of appreciate just how much work that is. Because you have to look at each and every record, each and every page going out the door to see what's in it. Because there will be protected information, things that are exempt from disclosure in a lot of documents. And so you have to go through and make sure you identify those, because obviously, the fire district doesn't want to be releasing people's social security numbers. It doesn't want to be releasing medical records it may have, if it had any, things like that. You have to call through all those records, identifying that. And that really takes a fair amount of time to do it properly. As you've processed, and my understanding is the fire district didn't do a lot with public records until the last little bit here. After you get a little more seasoned, your public records officer will be able to do it a little more quickly, but it's still the most time-intensive part of this, which is where installments come into play, and why, say that your search returned 10,000 pages. The PRA doesn't expect you to produce all 10,000 pages at once. You can go through and produce a reasonable installment, 200 pages, 300 pages, 100 pages. It all depends on what's reasonable, depends upon how fast you're pushing out these installments. And what does it take to kind of review those records? Because you have all the documents are reviewed that way, and then you produce the records to the requester. That's typically done through a letter. If you're charging for records, that says, dear requester, your first installment is ready. Please provide us with a payment of $10.52 or whatever the charge is if you're going to charge for that production. And that can include the mailing if there's an envelope, if it's being produced electronically and you put it on a thumb drive. All those built-in charges can be, that final production piece. You can ask the requester to pay for that. I had a conversation a little bit ago with somebody who was new to the public sector, and they came from the private industry, and we're really having a hard time wrapping their mind around the fact that this is a cost of doing business, and you're going to lose money on this, which is, that's the cost of transparency. That is what open government expects, because really, these aren't, well, they're agency records. The agency works for the people, and that's kind of what's baked into all of this. And so this is also where you might get into an installment loop. Say you're producing 200 pages at a time every 20 days or every 30 days. So you keep pushing out records, installment 1, installment 2, installment 3, up until you're done. And then there's a nice letter that says, "Dear requester, this is your final in production. We have produced all the records we've been able to identify. We are closing the request." Sometimes this will be easy. Sometimes this will take a matter of days to get through this process. For large requests, this could take months. There's a request that we at the AG's office have been working on for years because the person requested anything with the word diabetes in it. And so as you can imagine, in Diabetes Awareness Month and other health-related records, that word is very, very common. And so, like I said, we've been producing for years on this one, and the requester still gathers records every time we produce an installment. Is still interested in it, so we keep producing, which is, that's fine. That if he wants the records, we'll keep on this process. So let's talk a little bit about search responsibilities. And this is where we spent a fair amount of time talking with the chief when we were out there a couple of weeks ago. Want to share a little bit of information for you just about what's going to be happening. And then where we see agencies get into trouble is where they get a request and they just start kind of almost frantically gathering records. And we really encourage people to take a second, take a step back, think about what records do you think you have? Where might they be? What records are you going to search centrally, like email? For larger agencies, a lot of time that's happening, like there's one person who searches the email. If there's databases, who's responsible for keying in those databases? Smaller agencies like yours, that's easy. It's the chief and secretary. But they still have to plan out this search. Think about what the search terms are. What are the keywords? If it's an email search for emails between two people on a certain subject, what words are going to be used to find those records? Things like that. Where we've seen the most progression on this is we start talking about personal devices, and also why I shared with you that I will not use my personal phone for work is because once I cross that threshold, once I use my personal phone, I'm taking on those responsibilities to maintain those records, to search for records. If I have to produce them, I've got to figure out how to get them off of, if it's a text message, how do I get that off of my phone to give to my public records officer to produce them to the requester? If I was using my Facebook account or something else, how do I pull down those posts off my social media account to get those to my public records officer? Which is, I keep coming back to just don't do it. It's the easiest way you can do business. Because we'll talk a bit about retention in a second here, but you're taking on all those obligations if you start doing this. Because if you look at agencies, and this came up recently in one of the City of Tacoma cases, where when the courts are asked, and one of the common challenges to a PRA lawsuit is that the agency didn't do an adequate search for records. What the courts expect of us is to show our work. Much like, if you have children when they were in 5th grade and they were getting math and all of a sudden they could just write down the answer and you had to work with them in terms of, no, walk me through the process. Tell me how you got from, simplifying this to X equals 5. Give me each individual steps. That's what the courts expect for us in public records. They don't want to talk about what we generally do. City of Tacoma just had a case that didn't go well for them because the public records officer talked about the process generally. And the court said, great, that's a wonderful foundation, but tell me what you did in this case. And they couldn't tell what specifically happened. So part of what needs to happen in this entire process is good record keeping. Writing down, where did you search? Who was responsible for searching? Who was asked for records? What locations were searched? Think about your memory and what you can remember from last summer. If you were lucky enough to get a good vacation in the height of COVID, you probably have some really good memories, but the details of what days things happen have probably been eroded by time. That's exactly what's going to happen with the Public Records Act, and why it's so important that all of this happened within a central office, and that the public records officer be able to keep good records, and why your chief is probably going to email you about something and say, hey, tell me not just that you did it, tell me what you did. Because in a year from now, if you're in a PRA lawsuit, that way when you're working with your attorney and proving that you did a good search, because a lot of times agencies have, but it's, can they prove it? Can you show it? It's really, really important that you be able to keep that in mind. I said we were going to take a small side trip into the world of records retention. The Secretary of State's folks are the experts on this, and if you haven't had them out to talk with you, I really recommend that you do that. They're kind of weird, like we are in the PRA world. They like records retention, but what we can, the takeaway from this part of the conversation is that all public records have a lifespan. Sometimes it's a very short lifespan. There are things called transitory records, things like Post-it notes that I put on my computer to remind me of do something. Once I've done it, that's a transitory record. I can wad it up, I can throw it in the trash. More commonly, things have a lifespan of 2, 3, 4, 5, 6 years. Sometimes they're permanent retention. And there's a schedule for fire districts on the Secretary of State's website that tells you how long you need to keep things. At the end of that timeline, that same retention schedule is your license to get rid of stuff. And I fully recommend people follow those schedules. There are some things you're going to want to keep because it's significant. Say when you build a new fire station, they give you a lifetime warranty on the roof. Yeah, you're going to keep a copy of that lifetime warranty so that when it starts leaking in 15 years, they have to come back and fix it. That's probably beyond its retention schedule, but that should be a conscious decision. There's some people that are, I might need this someday. Don't fall victim to that. When you get to the end of that retention schedule, I suspect your chief is also your records retention officer. Let those records be destroyed. Put it in your document destruction log that on January 5th, we destroyed all of the emails from 2015 because they were past retention. Obviously, that's a broad statement. All emails you have to look at the content of each one, but just kind of an example. There are also some records that the Secretary of State office will take from you, and you should give them to them as fast as you can, because then they will take responsibility for them, and you are no longer responsible for producing those to a public records request, because that's provided that you don't keep a copy of them. If you keep a copy, then you've done yourself no service. But at the end, if things like council meeting minutes or the fire commission meeting minutes, I think about 6 years from now, they will want a copy of the minutes from this meeting. You should transfer it to them, because that way, if you get a request for the last 15 years of public records requests, the past 15 years of council meeting minutes, you can say, we have the last 6. For anything past that, go talk to the Secretary of State. They can pile them up there. That's what they do. They're very good at it. But it minimizes your burden. And that way you also know they're being retained properly, they're being stored properly. Because throughout all this is, again, that bottom line idea that these records aren't yours. The records are the agency's. And so they need to be managed. And if you start using your personal devices, all this is now invading your whether it's your computer or your phone. And what happens when you swap out your phone? Let's say, like, I've got an old iPhone 8, and someday it will die, and I will finally upgrade it to something. What happens to all those records? If I was using my personal phone for agency business, I would have to figure out a way to transfer those over to retain those for the rest of their lifespan, so to speak. And you're just far better off letting the agency deal with that, keeping it within the fire hall so that they can be managed effectively. So I wanted to give you a little bit of a foundation on exemptions, because I mentioned in that process that we have to review all those records. We're not going to release things that aren't that are exempt, things like social security numbers, because the foundation for all this is public records are presumed open. All those emails that we send as we're doing our job are presumed to be open to the public. People have a right to see them. And if we're going to hold something back, we have to be able to point to a specific exemption in state law, in federal law, sometimes in an international treaty, but we have to point to something. And it's not just enough to say, this is private. We have to be able to say, this is exempt under 4256 240 subpart 14, because this is a body worn camera of law enforcement and showing the interior of somebody's residence, something like that. And the burden is always going to be on your agency to prove that exemption applies. Exemptions are narrowly construed, meaning that the court will read the specific text. And if it says that a social security number is exempt, that's all that's exempt. An EIN that accomplishes the same thing, you can't cite that exemption to hold back an EIN. There's a whole separate exemption for those, but you have to find each one of those. And when you're producing records, if you're going to pull out the Sharpie or use Adobe or something like that to redact record, you then have to give an exemption log to the requester that lets them understand what they're not seeing. You have to cite what the exemption is and tell them how it applies to that record. Because just the idea of sending out a piece of paper, I'm sure you can appreciate how frustrating it would be for somebody just to get a piece of paper with black boxes on it and not understand what they're not seeing, and that kind of thing. The other thing that gets agencies in trouble from time to time, not very often, is silent withholding, where there is a record that they don't identify. So if there's something that is responsive to a records request, you don't tell the requester you have it, you don't turn it over, that's called silent withholding. If you want to see one of those high dollar judgments in the PRA, that's one the courts really have a hard time with. And I can appreciate that, because this is all about transparency. I want to talk a little bit about one specific one, because this really catches people off guard. There is no general privacy exemption in the PRA. There's a definition for privacy, but that's not a standalone exemption. You have to be able to point to something else. And I'll give you an example here for personnel issues. Information in personnel files is exempt from disclosure to the extent it would violate the right to privacy. And one of the questions that popped up was, what about evaluations? Are evaluations exempt from disclosure? And that's going to give you the attorney answer for that. It depends. For the rank and file, for like me as an assistant attorney general, my evaluation every year is exempt from disclosure under a case that's 20 years old now, called Dawson versus Daly. The idea being that my general performance is, it's been positive, and this encourages that positive, a good communication. And I've had to do this with folks that I've supervised, where they do a great job, but there's something we just need to work on. And so it fosters me being able to give that honest feedback to folks. The rule changes if there's a specific instance of misconduct. So let's assume that in one of my travels that I decided to take the state car and drive it like a Lamborghini, and I was doing 120 across Eastern Washington, got stopped by the Washington State Patrol. I guarantee if I had a job after that, that would end up in my evaluation. That would be a specific instance of misconduct. You would be able to get that piece of the evaluation showing that I had done something incorrectly. The rules change a little bit when we start talking about agency leaders. So the very top of the pyramid, so to speak, people who control the agencies, the rules shift. And there's some court decisions talking about how there's a heightened expectation, heightened interest in how they're doing. So like the chief's evaluation every year, that's not going to be exempt. If you had an assistant chief, that would be exempt as long as there was no specific instances of misconduct. But that's all because of this privacy idea. So I've talked a little bit already about production of records, so I'm not going to spend a lot of time with this. I've been going for a while here as well. But you should, when records are ready, let the requester know in writing that they're ready. It might be an email, it might be snail mail, depending upon how they're communicating with you. Inform the requester if there's any fee, how quickly they need to pay that fee to pick up the records, what's going to happen if they don't inspect the records, what's going to happen if they don't pay the fee within whatever timeline you establish in your policy. You'll see this in the model rules and in the samples that we shared with your chief. A lot of agencies are 30 days. That's not a short period of time. I've seen some agencies draw tighter windows around that. That's their choice. I personally am a fan of 30 days. It lets people go on vacation and get back and go, oh, okay, my records are ready, or to get busy with work or something like that. But then the whole idea is it's not, never in the PRA is there a gotcha moment. If your public records officer is approaching with that kind of a mindset, I guarantee you're going to have a problem down the road, because the Public Records Act, the public records officer really needs to approach this as a customer service kind of role. And that really is the mindset they need to have, because where you're going to get to if you don't take it that point of view is enforcement and penalties. And that's done in the courts, and the courts have discretion to do penalties is someplace between $0 to $100 per day per document. So think about, and a lot of times that turns into a per page calculation. And requesters have 1 year to file a lawsuit. So let's assume they file their lawsuit on day 360. They were withheld 100 records, and the court then imposes a $10 per day judgment. That's math, and that's something that attorneys don't do real well off the top of the head. I could do it if I put that down on my piece of paper, but I can tell you that's a pretty big number. And then on top of that, you're going to be paying attorneys' fees. They don't have to prove they were injured in any way. And like I said, the idea of this is to encourage your future performance, to get it right the next time, which is why you'll see some agencies go from, if the same agency is in front of the court repeatedly on Public Records Act cases, you'll start to see the penalties ratcheting it up, because it becomes apparent to the judges that agencies aren't taking it seriously. There are some specific rules when he's talking about inmate litigation and the folks that are at the Special Commitment Center. I'm not going to spend a lot of time on that. If you happen to see one of those, reach out to me. We can talk about it. In terms of touchstones, the takeaways from this part of the presentation, really take this to heart that public records of government agencies are presumed open. And this can be, I think this is a good thing. This is why I do what I do. I am very much a believer in open government. I also talk with people about when you find yourself typing an email to somebody and you're on paragraph 2 and your fingers are hurting so bad because you're slamming on the keyboard. That's a good time to walk away, because what you put in that email after you push send will live on. It has its own life. So sometimes the best thing you do is take a step back, collect yourself, come back, delete those 2 paragraphs, start over again, because everything you do is that people have the right to see it. Location doesn't matter, whether it's personal devices, whether it's agency devices, whether it's the filing cabinet that I used to have in my office. It's all about the content. And if we're going to hold those records back, we have to be able to point to a specific exemption, and those exemptions are narrowly construed. And if there's no exemption that applies and it's responsive to a records request, we have to produce it. And if you don't, that's silent withholding, and that will not go well for your agency. And then, of course, there is records retention laws that say how long we have to keep records. And I really encourage folks to know those and to live those. Public records requests have a 2-year retention period. Obviously, I tell people you should keep them for 2 years, but after that, it's your license to get rid of them, and you should. The Secretary of State has said that's an appropriate time to get rid of them. So let your public records live their life, and at the end of their life, let them end their life and send them to the shredder. That's why we have these document retention schedules. Other than that, that is an introduction to the Public Records Act for you from what you need to know as chiefs, as commissioners. Rather, if there's any questions from the commissions, I'm happy to answer those for you. If you think of one in a half an hour, feel free to send me an email, give me a call. This is what I do. I'm always happy to talk public records. So, and we are a resource. One of the nice things about this is when the legislature let us stand up this program, give us the directive to do it, they also gave us the funding to do it for free. And so this is, I'm like I said, I'm dedicated to public records and agencies getting it right. And that's why I am on this part of this program. That's why Lucy joined us. And so if we can help in any way, please give us a call. And someplace now I will return control back to the chief. Chief, who should I give should I give back to Mason 12?
Yes, please.
Be just a second here. It just moved on me. I was about to do it, and then Ms. Gonzalez became the top of my list. May Coast. Mayor Chief, you should have it back.
Thank you.
Okay. Any of the commissioners have a question for Morgan while he's still here? Do you have any questions for Morgan, John?
Yeah, Morgan, I got a link going to the Washington State Archives Local Records Grant Program.
Mm-hmm.
You familiar with that and how we might be able to get involved in that?
Yeah, that's a program that stood up the same time we did, and it's basically it is a resource for local governments divided into 3 sections. I'm going to butcher the categories, but basically it is technology, cleaning up old records, scanning and tossing, things like that. And the third one that's escaping me. And every 6 months, I believe it is, you can fill out an application to be awarded a grant of whatever amount of money that you need. I've seen some very small ones for $1,000. I've seen some agencies be awarded thousands of dollars. Sometimes it's been to hire staff or temporary hire staff to, just to go through the stacks of boxes they have in the back storage room that have been over the course of time ignored and getting on top of it. I will send the chief a link to it as well, with some additional information, but I suspect it's the same stuff you find on your website. And they have, I believe the process is about to open again for another round of grants.
Okay, thank you.
All right, well, we thank you very much for your time, Morgan. We appreciate it.
No, and I'm weird. I like this topic. People think, what did you do wrong that you have to talk public records all the time? Yeah, I'm kind of a public records nerd this way. So happy to be a resource for you.
Well, we certainly appreciate it. Okay. So,
Correspondence?
any correspondence? Chief's report?
Last month, we had 17 calls, we had 10 EMS and 7 fire. That's it.
All right. So we will be going to an executive session for 10 minutes for RCW 423110 to receive and evaluate complaints or charges brought against a public officer or employee. So we will be going at 3:12 and return at 3:22. Okay, we are back. So, commissioners, you have anything else, Brian?
I have nothing.
Do you have anything else, John?
Nope, nothing for the good of the order right now.
Neither do I. So I make a motion to adjourn the meeting at 3:23.
I'll second.
All in favor?
Aye.
Aye. We thank you all for attending.
Minutes to sign?